All right. Good afternoon, everyone. Again, I'm Ian Friedman, and before I begin, I just want to say it is a pleasure, it is an honor whenever speaking to colleagues, so I appreciate you having us here. And as Steve said a moment ago, this presentation really changed just days ago. The open discovery debate, the Rule 16 debate had been going on for decades. In the last couple of years, it's really kind of gained momentum on both sides. For the last 2 years, I believe coming up on 2 years, kind of the latest effort was a group of prosecutors and defense lawyers. We've been meeting mostly in Columbus, and last Thursday, right about dinner time, we kind of went around the table, polled one another, and realized that we had actually agreed upon a version for broader discovery that would be going to the Rules Committee and hopefully ahead for adoption by the Supreme Court. So I felt that it was important, and I called Steve and said, doesn't make a whole lot of sense for me to get up there and kind of say, here's the problems. So I think that what I want to do is go over the history of the discovery. Most of you know it. You'll have specific instances of problems and kind of your own experiences with discovery. But kind of the history and how this process has kind of unfolded to get us where we were last Thursday. And so I called the gentleman that we've been working with at the OPA, and Dave has been involved in the open discovery or Rule 16 debate now for several years and is part of the Rules Committee. He was there with us at every meeting and really took the time and spent the resources, he and his office, to get this done. And I have to say what it was rather remarkable, I think, and I'll just speak very personally for a second. No one thought that we were going to reach an agreement. When I took over with OACDL and said, well, we're going to continue to work on open discovery, everyone kind of said, yeah, right. And with good reason. It just hadn't materialized from either side. And so last Thursday, when we finally finished that, it was a very proud moment, and not to be a defense lawyer, and from what I gathered by the other folks there, not just being a prosecutor as well, but just being a lawyer. Because what happened was when we finally took to kind of the same side of the table and looked at the debate rather academically and asked ourselves as lawyers, how can we better the system? How can we make it fair to all and so that it works to protect all? We really were able to move forward. And so Dave Yost, again, the Delaware County prosecutor, has graciously agreed to speak with me, and I think that was only appropriate. You'd only be getting half the story without him, and I didn't think that that was fair to you folks, or fair to the rule, or fair to them. And so as hokey as this may sound, I personally want to say thank you to Dave here in front of everyone, because he deserves it. And so from one defense lawyer to a prosecutor, thank you for helping us with Rule 16. And so today, what I'd like to do is just kind of move forward through the process very quickly. But I'd like to have Dave come up, and if you want to introduce yourself, and then we'll just kind of go through the where we were, where we are, and where we're going.
The only thing I would like to add to what Ian said, and I have been involved with this debate for about 4 years now on the prosecutor's side, and he really brought a fresh perspective to the debate. The problem we've had since the rule was passed is Criminal Rule 16. For those of you who've been around for a while, you realize, but it's one of the few rules of procedure that has never been amended or updated at all since it was originally adopted. And the reason is perhaps there is no more adversarial, we have an adversarial process, and there's nowhere in the criminal or civil rules probably where that adversarial process is more focused than Rule 16. So it really was a remarkable thing, and I think after we go through the current situation and we begin to outline for you the new proposal, you'll see that it's really quite a sea change, I think, for both sides, but that it will end up producing better results.
Very I agree with that. So as you all know, here was the problem, as we would allege, that you would get the language for a burglary, did by force, stealth, or deception, trespass as defined, and just regurgitate the language of the revised code. This, at this point, did not, we felt from our side, advocates for greater reform in Rule 16 feel that this put someone or gave sufficient notice as to the nature of the charge. Now, this next slide. I've given this lecture before with other folks.
Ian was the one to put this slide together. That might not surprise you.
So, now what I did was, in past debates with folks, and this was before the agreement, what you would have is kind of this. It was a little subliminal every time they were getting up there to speak. But I will get to kind of the union of it here shortly, and that slide is no longer necessary. So, of course, we all file our request for discovery, the basics, tell us what the case is about, and what we ended up with was regurgitation of the language. In subsection D, all witnesses, our contention has always been, it's a problem when it comes back saying representative, 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 representative. And again, that didn't really allow us to prepare our cases. So that was the first bit of information we needed. And of course, we hoped that when we got the bill of particulars, that would place us on greater notice of the charge. And it lets us know there that the person did unlawfully, did by force, stealth, or deception, trespass, et cetera, the Ohio Revised Code. Now, under the case law in Ohio, that was okay. And pursuant to Criminal Rule 16, the argument was valid from both sides. Yes, we need more for fair trial, for due process, and Sixth Amendment rights. And if you want to talk for a second about why Rule 16 was sufficient, or kind of what the argument was at that point, I should say.
The argument by the prosecutors has always been that there are several problems with giving up what we would have as full disclosure or the full discovery in the civil realm. First of all, remember that constitutionally we don't have a level playing field, and well, we shouldn't in criminal law. The state bears the burden. The state has to carry that proof beyond a reasonable doubt. The state doesn't have a right to a fair trial. The defense does. And there were some problems in a small number of cases that really drove the original drafting of the rule. One is what prosecutors like to call the roadmap to perjury. Doesn't happen too often, but when every single line of every single piece of work done by anybody is available to the defendant, surprisingly, they occasionally will fabricate a story to try to explain away the evidence. And we actually had one major murder case in Delaware County where that happened, and it's happened in other jurisdictions. The second area is witness intimidation or coercion. And this happens from your garden variety misdemeanor domestic violence all the way up through serious gangland kinds of cases. And we've had stories about victims of domestic violence and their statement in an open discovery jurisdiction being confronted by the defendant with that statement. Why are you ratting me out to the police? We've had informant statements copied and stapled up on the telephone poles in the neighborhood. Pretty clear message. We had one instance, was reported last year, where there was a local record